Dear all, welcome to this webinar, which is really a web appeal in a situation we believe to represent a grave threat to the system protecting the rights of all European citizens. My name is Ivar Ørstavik. I'm a senior advisor at the Rafto Foundation for Human Rights. Millions of Europeans live and work in another country than that in which they were born. Trillions and trillions worth of goods, services, and investments move across European borders every year. Without rule of law and independent judges to protect our equal basic rights, those among us with little power and money will exist at the mercy of those among us with a lot of one or both of these. The legal system set up to protect our rights have never been perfect. Now, however, it is breaking down. The breakdown starts in Poland, where European law and the European Court of Justice is no longer respected by the state. But it will not stop there. Our speakers today will explain what this means. The problem is the system, but it is of concern because it affects us, the people living and working in it. One among us will fight a very important battle this Monday, October the 5th. He is a judge in Warsaw, and his name is Igor Tuleya. Igor Tuleya has made rulings in court which displease the most powerful men in Poland. They do not appeal the ruling. Instead, they want to punish the judge. I will start the webinar by giving you an opportunity to form an impression of this man.
Jestem. Proszę bardzo, sędzia Sądu Okręgowego, członek Stowarzyszenia Justicja. W tym, że zostałem sędzią, tak naprawdę to jest bardzo dużo przypadków. Skończyłem humanistyczną, więc wiadomo było, że nie będę studiował medycyny, bo się nie dostanę, pomimo że jako hipochondryk zawsze chciałem być lekarzem. Bałem się, że się nie dostanę na jakieś inne humanistyczne, bardziej elitarne kierunki, więc poszedłem na prawo. Dopiero jak zobaczyłem, jak to prawo tak funkcjonuje w praktyce, jak ten sąd wygląda od kuchni, no to uznałem, że jeśli mam wykonywać jakiś zawód prawniczy, no to tylko zawód sędziego. Niestety zrezygnowałem z moich planów dotyczących historii prawa. Co jest fajnego? Rozstrzyganie sporów, rozstrzyganie jakichś problemów. Też jest fajne to, że to, co się wydarzyło w ciągu tych ostatnich kilku lat, że ta praca sędziego nie ogranicza się do sali sądowej, ale że wyszliśmy z sądów do ludzi, więc te spotkania z obywatelami to też jest bardzo cenne doświadczenie. Myślę, że to jest fajne. Spotkałem się z tym, że ludzie właśnie zarzucają bezduszność sędziom, zarzucają to, że sąd jest takim zimnym urzędem. Sędzia nie może być cyborgiem, nie może być maszyną do stosowania przepisów i do wydawania orzeczeń, tylko musi być najpierw człowiekiem, żeby zrozumiał drugiego człowieka. Dopiero będąc tym człowiekiem, jest w stanie zastosować odpowiednio przepisy, ocenić sytuację, zastosować odpowiednio przepisy. Tak to sobie wyobrażam. W Polsce od 3-4 lat niszczona jest władza sądownicza, niszczona jest niezależność sądów i niezawisłość sędziów. Robi to władza wykonawcza. Minister Sprawiedliwości obecnie wyznacza sędziów dyscyplinarnych, wyznacza rzeczników dyscyplinarnych, ma swoją izbę dyscyplinarną, może domagać się wszczęcia postępowania dyscyplinarnego, może odwoływać się od decyzji, które zapadają w tym postępowaniu dyscyplinarnym. Krótko mówiąc, całkowicie podporządkował sobie postępowanie dyscyplinarne. Byłem uczestnikiem 8 postępowań dyscyplinarnych. No jest to oczywiście fatalne uczucie. Te przesłuchania, w których ja uczestniczyłem, one wyglądały w ten sposób, że je prowadziło 2 rzeczników dyscyplinarnych i były nagrywane. Jeden zajmował się kamerą, a drugi zadawał pytania. No oczywiście nie jest to komfortowa sytuacja, jak trzeba odpowiadać na pytania i człowiek ma takie poczucie, że jest albo podejrzanym, krótko mówiąc, takie poczucie bycia przestępcą. To nie jest fajna sprawa. Takie postępowanie oczywiście mają utemperować nie tylko konkretnego delikwenta, sędziego, ale również mają utemperować pozostałych sędziów, całe środowisko sędziowskie, czyli mają spowodować ten efekt mrożący. Sędziowie właśnie za wyroki, które z jakichś powodów nie podobały się rządzącym, byli ścigani albo już byli karani w tym postępowaniu dyscyplinarnym. Czyli czy można mówić w ogóle o niezależnym sądzie w sytuacji, kiedy taki sąd jest steroryzowany przez ministra sprawiedliwości, przez polityka? Czy można mówić, że to postępowanie sądowe rzeczywiście jest uczciwe, jeśli sędzia, który prowadzi je, może się obawiać, że jeśli podejmie decyzję, która nie zostanie zaaprobowana przez rządzących, natychmiast jest wszczynane wobec niego postępowanie dyscyplinarne. W sytuacji, kiedy tak naprawdę postępowanie dyscyplinarne, czyli ten bat jest w ręku polityka i ten bat jest używany, żeby podporządkować sobie sędziów, no to nie można już mówić o niezależnych sądach. Te restrykcje na sędziów będą się zwiększały, to dokręcanie śruby będzie większe. Chodzi o to, żeby po prostu złamać te sędziowskie kręgosłupy, jeśli nie wszystkim, no to tym sędziom najbardziej aktywnym. Jeśli im się złamie kręgosłupy, jeśli ich się wyeliminuje, no to zadziała ten właśnie efekt mrożący, że jest duże prawdopodobieństwo, że sędziowie już nie będą się wychylali, stracą atrybut niezawisłości i z sędziów przeistoczą się w takich posłusznych urzędników.
So, am I on? These were the words of one of the very many judges and other civil servants in Poland who have placed their careers and their livelihoods on the line in this struggle about rule of law. With us today, we have 3 judges and 2 legal experts to expand and explain the context and the critical junctures of this struggle. We have Professor Laurent Pech, Professor of European Law and Head of the Law and Politics Department at Middlesex University. He is also formerly Jean Monnet Chair of European Public Law. We have Darius Mazur, who has judged at the City Court of Krakow in Poland and a spokesperson for the Judges Association Themis, and also a member of the judges organization Justitia. We have Mikael Sjöberg, judge and vice president of the European Association of Judges, and Philippe Marques, judge and president of MEDL, Magistrat Européen pour la démocratie et la liberté. Finally, we will have a word from Pavel Filipek, who represents the ombudsman for human rights in Poland, and Rafto laureate 2018, Adam Bodnar, who could not be here today. First out, Laurent, the web is yours.
Thank you very much, and good morning to everyone, good morning to my fellow panelists and everyone listening. I'm just going to ask you to imagine a country where national authorities are engaged in actions such as the ones I'm about to describe, and I'm going to ask you to ask yourself whether what I'm describing can be real in the EU in the 21st century. Imagine a country, to begin with, where the executive and the legislative powers have organized the unlawful capture of the Constitutional Tribunal in open breach, obvious breach of the Constitution. Imagine a country where the Constitutional Tribunal is presided by an individual unlawfully appointed to the tribunal. Now, imagine a country where this unlawfully composed tribunal is just simply sitting aside while the Constitution is openly, regularly violated by national authorities. Imagine a country where the National Council for the Judiciary, the terms of the mandate of the sitting members of the National Council of Judiciary are just prematurely terminated in obvious breach of the Constitution. Imagine a country where presidents and vice presidents of ordinary courts has just see their terms, their functions terminated on the basis of a one-sentence fax sent to their courts without any reasoning, without any remedies, without any appeal process possible. Imagine a country where the ruling party has also captured the Supreme Court with another unlawfully appointed president. Imagine a country where the Constitution has been openly violated to establish a disciplinary body which is reminiscent of the English Star Chamber from the Middle Ages, to the extent that he has no independence whatsoever from the government, and by this essentially any independence from the ruling party and other governmental parties. Imagine a country where the national authority regularly violate or simply refuse to comply with any rulings they simply don't like for political reasons. Imagine a country where essentially now judges can be punished at will on the basis of grotesque, Kafkaesque procedures. For what? For which crime? The crime of applying EU rule of law standards. Imagine a country where national authorities are getting away with the setting up of a secret online troll farm hosted within the Ministry of Justice, whose main job is to scare and intimidate judges and their families by leaking confidential information to pro-governmental outlets. Imagine a country where judges can be not only subject to disciplinary proceedings, but disciplinary sanctions such as a pay cut for the crime of applying a ruling of the Court of Justice. Imagine a country where judges can be subject to bogus, fabricated criminal charges so that they can be dismissed from the judicial branch. This country is not a fictional country, I'm afraid. Every single example I've provided with is actually something which has happened in Poland. We have now reached the stage where in Poland, they just decided a so-called disciplinary chamber, which we're going to discuss this morning, has just decided to void a preliminary ruling of the Court of Justice, even though it has been previously suspended by the same Court of Justice. What we are talking about as far as the situation in Poland is concerned is not simply the rule of law being attacked. As we said, a number of us in a recent open letter to the President of the European Commission, the rule of law is not being attacked in Poland. The rule of law is being annihilated. It is being destroyed. Judicial independence has been structurally disabled. There is no such thing as left as judicial independence nowadays in Poland, because the national authorities of Poland have organized the structural violation of all the Polish EU and ECHR rule of law standards. So the disciplinary chamber and the case of Judge Tuleya is in fact just the tip of the iceberg. This is really a pressing existential threat to the EU legal order. This is not simply an issue for Poland. We should think of Poland as a rule of law dam. if the dam breaks in Poland, this is the collapse of the EU legal order with this autocratic blueprint, no doubt, going to be exported and used elsewhere. This is why I call everyone to please step up and do help assist the brave Polish judges, Polish prosecutors who are taking a stand for the rule of law. This is a time also for EU institutions and especially the EU Commission to finally do its job properly, promptly, and with resolve. And this is why I'm going again to ask for the President of the European Commission to please do their job as guardian of the treaties and issue the reasoned opinion as regards the rule of law, and return to the Court of Justice and ask for the imposition of a daily penalty payment against Polish authorities for deliberately violating the ECJ order of 8 April 2020. Thank you very much.
Thank you so much, Professor Pech. I then pass the word to Judge Darius Mazur.
Okay. Thank you very much for giving me the floor. Professor Peck started from quoting Imagine by John Lennon, however, in reversed way. I will start from quoting well-known Polish aphorist from the beginning of 20th century, who said that even illegality can be codified. And that is exactly what is happening in Poland now, since the time when the Constitutional Tribunal was politically subordinated in December 2016. How does it look like in very general terms? The general rule is very simple. There were created two politicized committees in order to subordinate judiciary. The first is the Neo-National Council of the Judiciary, which is responsible for appointment and promotion of judges. The second is the Disciplinary Chamber of the Supreme Court, which is responsible for legal harassment of defiant judges. If the politicians control, on the one hand, who will become a judge, which judge is going to be promoted, and which judge will face the disciplinary proceeding, including possibility of professional death, have we called removal from the profession, then the independence of the judiciary becomes strictly illusory. The Minister of Justice has full control over the Public Prosecution Office, over the disciplinary commissioners, and he has also excessive scope of administrative control over the judiciary. All of these factors create a great potential of intimidation of judges. We face the real chilling effect generator. This idea of political subordination of the judiciary is supported by the massive Black PR anti-judicial campaign, which is conducted via public TV, internet, billboards in the streets. All these tools of oppression, which I shortly describe, are engaged to suppress judicial independence and to disable application of the EU law by the courts. How does it work in practice? On the one hand, we have soft administrative ways of repression. In 2017, on the basis of intertemporary provisions, introducing the new law on organization of ordinary courts, the Minister of Justice conducted purge among the presidents and vice presidents of the court. Namely, he replaced 160 presidents and vice presidents before their terms of office expired. The main criteria for appointing their successors was the degree of their loyalty to the Ministry of Justice. They are supported by politicized court managers, and they can apply, and they apply soft, we call it soft, administrative measures of repression in respect of defiant judges, such as, for example, unjustified transfer of judges between divisions of the court, deteriorating of working conditions by depriving judge of proper administrative service, even liquidation of the court division in order to deprive particular judge of his function, and also revocation of judges from the delegation to the upper level court when the judge seems to be not obedient enough. When the judge faces such a situation that he's thrown to the new unfamiliar ground, where he's overwhelmed by the massive workload of the new cases and deprived of proper administrative service, such a person is prone to commit a judicial error. And that's the way how the proper disciplinary proceeding can be prepared via these soft administrative ways of repression. And that is what Judge Jurek, ex-spokesman of the old National Council of the Judiciary, faced. And also, and mostly, we have these hard measures of repression, which can be applied in two ways. Firstly, by instigating disciplinary proceedings in respect of judges. Secondly, in a way of instigating of criminal proceedings in respect of judges. With disciplinary proceedings, it is really easy to start and to continue because we have entirely new mode of disciplinary proceedings, which was introduced at the beginning of 2018, which gives the Minister of Justice the excessive control over these disciplinary proceedings. It is not only that Minister of Justice appoints the main disciplinary commissioners and all justices of the first instance disciplinary courts, but there is also permissible to carry out a hearing in disciplinary proceedings in justified absence both of the judge and his legal counsel, and there is possibility to apply evidence obtained without judicial control and in violation of law in this mode of proceedings, including evidence from operational telephone taping. All in all, we have an inquisitional model of disciplinary proceedings against judges, which politicize these proceedings and restricts the procedural rights of the defendants. And lastly, at the top of this new mode of disciplinary proceedings, we have disciplinary chamber, which is separate specialized court, which is not provided by Polish constitution because creation of such court is possible only in the times of war. So it is not a court provided by law under Article 6 of European Convention of Human Rights. And this body stands for the politicized second instance disciplinary court for judges of common courts. And this new organ soon proved to be politically subordinated, punishing judges for the content of judicial decisions. We face such situation in cases of judges Czubieniak and Juszczyszyn, and it can happen also in case of Judge Tuleya soon. The second branch of hard repression is possibility to instigate criminal proceedings in respect of judge. It is possible due to the fact that in 2016, the ruling camp took political control over the Public Prosecution Office by combining functions of Minister of Justice and Public Prosecutor General, which has been accompanied by significant increase of his investigative powers. In particular, he can issue binding commands with regard to the particular procedural steps in individual cases and appoint all superior prosecutors instead of competition procedure applied before. At the very top of Public Prosecution Office, there was created Internal Affairs Department of the State Prosecution Service, which task is to conduct preparatory proceedings in cases of crimes committed by judges and prosecutors. After 2 years of its activity and analyzing more than 1,100 cases and claims, they were able to instigate only 2 criminal cases against the judges. If we take under consideration that there is about 10,000 judges in Poland, it is absolutely clear that this body lacks substantive justification other than just intimidation of judges. And I must emphasize that this way of legal harassment, so via criminal proceedings of judges, became popular since freezing of the Disciplinary Chamber by the Court of Justice of the European Union in April this year. What are the categories of sensitive situations? So the cases which can cause, which can instigate soft or hard measures of repression in respect of judges. So when these measures appear, for example, in a case in which a party is a politician or state-owned enterprise or company, judges who refer preliminary requests to the Court of Justice of the European Union or Supreme Court can be targeted. Judges who contest legal status of new chambers of Supreme Court, neo-national council of the judiciary, or the legal status of judges appointed with participation of neo-NCJ. Judges who refuse prosecutors' motion to apply preliminary detention. Judges who decide on the basis of constitution or international law. Judges adjudicating in high-profile cases widely presented in the media where it is easy to gain political capital on the basis of such cases. Judges protesting against the breach of constitution, politicization of the judiciary, criticize new disciplinary authorities. Judges involved in legal education of children and young people. Members of the boards of judicial organizations, and quite recently, signatories of the OC letter regarding parliamentary elections in which the 1,278 judges are targeted. So all of these categories of cases and judges can face administrative persecution, disciplinary proceedings, or criminal proceedings, and there are numerous examples of such situations. And this list is not exhaustive at all. These are just examples. So the general idea is that it is difficult to predict which case has such potential. So in fact, actually, every judge can feel threatened. And just at the end, how does it work with my personal situation? I've been sitting as a judge of ordinary court for almost 24 years. During first 20 years of my judicial career, I succeeded in becoming quite a renowned judge, perceived as specialist in the field of international cooperation in criminal matters. Within recent 2 years, I was deprived of the position of coordinator of the international cooperation in criminal matters of Kraków region. I was removed from the position of the lecturer of the National School of the Judiciary and Public Prosecution. I was banned to give lectures in the European Judicial Training Networks and for the Kraków Advocacy Bar. Last but not least, I'm also facing explanatory proceedings for criticizing in the independent media the policy of the Ministry of Justice, which in my view fosters corruption among the judiciary, and I'm accused in proper disciplinary proceedings for hanging up in the court a poster with demands of judicial association. Actually, there is only one reason of this legal harassment which I experience. I'm the spokesperson of the Association of Judges Themis, which is the second largest association of judges in Poland. So I'm active in the independent media, where I criticize this pseudo reform, which is designed to politically subordinate the judiciary. That's why I'm treated like a public enemy. However, I'm not definitely the most targeted judge in Poland, because comparing my situation with situation of such judges like Judge Tuleya, Judge Frąckowiak, Judge Żurek, Judge Juszczyszyn, I can feel almost untouched. Thank you very much.
Thank you so much, Judge Mazur. I'm tempted to leave a minute for the audience to let this sink in its gravity and complexity, but we don't have time. So I'll pass the ball on first to Mikael Sjöberg, who is Vice President of the European Association of Judges, to hear his comments on this. Vice President Sjöberg is on tape, so we're having a little hiccup here.
Yeah.
There he comes.
My name is Michael Sjöberg. I should have liked to participate live in this web seminar, but when you sent this, I'm unfortunately in court. I'm Vice President in the European Association of Judges. The European Association of Judges is the largest association of judges in Europe, and it covers 42 members. The Polish Association of Judges, Judiciary, is an estimated and very active member of the organization. In any event, the European Association of Judges, which works for justice and legal independence, do as much as we can to help its Polish colleagues in the struggle for rule of law in Poland. The European Association of Judges notices with great concern the recent development in Poland regarding the upcoming hearings by the Disciplinary Chamber. And I mean the hearing of Judge Igor Tuleya on October the 5th, the hearing of Judge BEATA MORAWIEC in October the 12th, the hearing of Judge IRENA MAJCHER on October the 21st, and the hearing of Prosecutor Krzysztof Pagomowicz on October the 16th. I'm sorry for my pronunciation. I hope you could know what I mean. We are very concerned about these hearings. They are not in accordance with the principle of rule of law and with the principles of a free and independent judiciary. A judge who fears a disciplinary case is not an independent judge. Poland is a member of the EU. The European Court of Justice has recently issued a number of judgments critical to Poland's compliance with EU law. On April the 8th, the European Court issued interim measures ordering the Disciplinary Chamber of the Polish Supreme Court to cease hearing disciplinary procedures against Polish judges while the proceedings, as whether this disciplinary chamber is an independent body complying with the requirements of EU or not, are pending. This ruling is obviously mandatory to Poland. However, in complete disregard and disrespect of the European Court, the Disciplinary Chamber continues its activities, which is an attack on Polish judges, their associations, and the rule of law in Poland. The actions taken by Polish authorities in recent times, openly disrespecting the interim measures taken by the European Court of Justice, are a clear sign that Polish political authorities will continue to persecute independent judges that act in defense of rule of law. A few days ago, 37 prominent academics sent an open letter to the European Commission in which they, among other things, said, "The rule of law in Poland is not merely being attacked, it's being destroyed." Very strong words which the European Association of Judges made its own by endorsing the letter to the Commission. The day before yesterday, 4 different European associations, among them the European Association of Judges, sent a letter to the President of the European Commission, Mrs. Ursula von der Leyen, calling up for action here and now. Among other things, they asked the Commission to request the European Court of Justice for penalty payment regarding the continuing violation of interim measures in order to prevent the Disciplinary Chamber from proceeding with any activities. They asked the Commission to start infringement procedures against Poland for breach of European law, as recommended by the European Parliament. And finally, they asked the Commission to address the Minister of Justice in Poland, which is also the current Prosecutor General, urging him to abandon the proceedings against judges. A week ago, I had lunch with the Danish Minister of Foreign Affairs. We discussed the situation in Poland, and on behalf of all European judges, I strongly encouraged him to work for the rule of law principles in the Council of Europe. He promised to do that. I don't know if any or just some of these efforts will have any positive effect on the rule of law and the severe situation for the Polish judges. But I can promise you that we will go on and do our best. What's going on in Poland shall not happen in secrecy. Thank you.
Thank you very much, Judge Sjöberg. I then pass the word on to Judge Felipe Marquez of Medel.
Good morning. I hope you all can hear me well. Let me first of all thank Rafto Foundation and Igor Tuleya for the invitation to Medel to be present in this important event. Medel is a European association it's an umbrella association that gathers associations of judges and prosecutors. 23 associations of judges and prosecutors coming from 16 European countries. We also have been quite active in the support of our Polish colleagues. We have as our members Justitia, the Polish Judges Association, and Lex Super Omnia, a Polish Prosecutors Association. So we've been watching with great concern the situation which is currently unfolding in these last years in Poland. You can, as you have heard from Michael Sjöberg, we have addressed together with other 3 associations of judges, the European Association of Administrative Judges, the European Association of Judges, and Judges for Judges, a Dutch foundation. We have addressed a letter to the European Commission President. It's published on our website. And we have supported a very much appreciated letter signed by many academics denouncing the situation of the rule of law and urging the European institutions to act. We've been speaking in this webinar and in a lot of other events about what is going on in Poland. And it's, as anyone that has studied law understands, it's very hard sometimes to get out of this law community and to reach out to citizens and explain them why is this so important. So we have heard from Darek and from many other Polish colleagues about what they are suffering. What I would like to say, to try to say to everyone who is listening to this webinar is, why should we all, regardless of being judges, prosecutors, lawyers, or having nothing to do with law, why should we worry about this situation? First of all, this is about democracy. Democracy is not about imposing a majoritarian will. Obviously, governments and parliaments are elected by a majority of voters who express their will in the ballots. But democracy is also about protecting the rights of minorities. And that's what makes the difference between an authoritarian regime and a democracy. And in the system of checks and balances that any democracy relies on, courts are a crucial element, because it's in courts where anyone, regardless of belonging to a majority or not, regardless of its economic status or power, or its lack of economic power, gets to see its rights upheld. And this is an important point that we should focus on. And this is what makes the difference between rule of law and rule by law. We cannot have courts which are under the control of the executive. We cannot have prosecutors who receive direct instructions from the executive, because if that happens, we will have a justice system which is a tool for a majoritarian will to be imposed. And what we need is independent courts that, regardless of majorities or minorities, use the power invested in them by the constitution of the country to defend the rights of citizens, regardless of their position. There's no better story than the one from the Miller of Sanssouci, which is quite widely known, which in the end of the 18th century, when the Prussian emperor threatened him of taking the windmill off him, saying, "Aren't you aware that I can just take the windmill from your hands without paying you a dime?" He replied to the emperor saying, "I'm perfectly aware of that, Your Majesty, but there will always be a judge in Berlin to prevent you from doing that." And this story explains exactly what courts are for. They exist to protect the rights of citizens. Democracy is based on a majoritarian will in elections. It's based on free media, so a free debate can occur, so people can debate freely their ideas, and free courts and independent courts that exist to protect citizens' rights. And this is why it is so important for any citizen, regardless of being judge, prosecutor, lawyer, or having nothing to do with law, to be so worried about what's happening in Poland. And most of all, why should we, citizens of outside Poland, why should any European citizen be concerned about what's happening in Poland? Well, I would say that human memory tends to be short, but when we look 80 years back and we remember that our grandparents were fighting and killing each other in the most horrific war the world has ever known, and we look that 80 years later, we can cross borders without any formalities. We send our children to study in universities in other countries. We see our children studying with colleagues from other European countries. If we think, how have we achieved that in just 80 years? How have we achieved the longest period of peace in the European continent? We have achieved it through dialogue. And this dialogue is a dialogue of governments in the European Commission and the European political institutions. It's a dialogue of European peoples in the European Parliament. And it is also a dialogue of European courts in the European Court of Justice, who guarantees that the European law is applied in a uniform way in all the continent. This is what guarantees that any citizen from any country in Europe can move freely to another European Union country, can run its business, his business there, or can get married there, or can buy any property there, and he can be sure that he will be treated equally as if he or she in his own country. And we have a legal structure and a court structure and a judicial structure, which is based on national courts. We have one court in Luxembourg that ensures that the EU law is applied uniformly in all European space, but we rely on national courts. And if in one of these countries, as it is now happening in Poland, this system is being put at risk, we all in any European country are at risk, because we can no longer trust in that uniform application of EU law. We can no longer trust in an equal treatment in all countries. So this is why the European Union citizens, regardless of being Polish or not, should be worried with this. This is why this is not a problem of Polish prosecutors or judges. So basically what we are talking here about is democracy, because courts are a part of a democratic system. And we are talking about peace, because this is one of the key elements of the peace that we were able to build in these last 80 years. And this is the message I would like to transmit in this webinar. It's a problem of rule of law, and rule of law should concern us all, regardless of our nationality, regardless of our profession. This is why we stand with the Polish prosecutors, judges, and lawyers who are being attacked. And this is why it's so important to have the civil society involved. And this is why I thank Rafto Foundation for another important event. This is why I thank Laurent Pech and all the other academics that are involved in this struggle. And above all, this is why I'm thanking our colleagues from Justitia, from Lex Super Omnia, all our free Polish judges who are struggling, not for them, but for all of us in Europe. So thank you very much, and let's keep our fight going.
Thank you very much, President Marquez. Now we have heard the matter as experienced by 2 judges in Poland suffering persecution. We have heard the point of view of the academic community and the international community of judges. The last main contribution here will be from Dr. Paweł Filipek, who represents an office mandated to monitor the rule of law in Poland, the Ombudsman for Human Rights in Poland. He stands in for Rafto Laureate 2018, Adam Bodnar. Please, Dr. Filipek.
Well, thank you very much. Let me start by just conveying greetings from the Polish Ombudsman, Mr. Adam Bodnar. He's always happy to work with the Rafto Foundation and is unhappy not to be here with us today. As to the merits, I would like to make 4 points. Point number 1, the Polish Ombudsman considers that the Disciplinary Chamber cannot adjudicate in the case of Judge Igor Tuleya, as in the case of Judge BEATA MORAWIEC, as in the case of any judge for that matter. The chamber has been established in violation of the law and has been staffed in a process that has not guaranteed the independence and the impartiality of the persons appointed. This stance was taken also by the Polish Supreme Court in the resolution of the joint chambers of 23 January this year, the one implementing the ECJ judgment, AQ and others of November 2019. Furthermore, as was already mentioned today, the European Court of Justice in its decision of April this year recognized that the independence of the disciplinary chamber may not be guaranteed, and the chamber may pose a threat to the independence of Polish courts. For that reason, the chamber got suspended. The continued judicial activity of the disciplinary chamber, despite interim measures, indicate that the decision of the Luxembourg court is not fully respected. The Polish government should therefore anticipate a supplementary request from the Commission to the court to ensure that the April decision is fully complied with. Point number 2, the measures taken against Judge Tuleya are only an example of intended systematic action against Polish judges. The system of disciplinary liability, the administrative measures, and as it's now the case for Judges Tuleya and Morawiec, the initiation of criminal proceedings are currently applied with the intention of breaking judicial independence. The initiation of disciplinary proceedings has become a normal practice for disciplinary prosecutors and is used as a routine tool to intimidate judges. In the opinion of the Ombudsman, the lawmaker deliberately designed the current system of judges' responsibility in such a way as to use it as an instrument of control over judges and courts. The measures taken demonstrate constant and intentional pressure on judges applied in a programmed and immediate manner. My point number 3. The Polish Ombudsman has been actively participating in European court proceedings related to the rule of law and judicial independence, including those initiated by Judge Igor Tuleya. The Ombudsman is a party to 5 such cases brought by Polish courts to the Court of Justice in Luxembourg. In all of them, the Ombudsman presented written positions. In 4 of them, his representatives participated in the hearings before the court's grand chamber. One of the cases was initiated by a preliminary reference made by Judge Tuleya. In its ruling of March this year, the ECJ made it clear that the right of a domestic court to refer a question to Luxembourg is covered by the guarantee of independence. For that reason, there can be no negative consequences for the judge. Even as the case may be, the referred question remains unanswered or is declared inadmissible. And we should remember that one of the disciplinary proceedings against Judge Tuleya were initiated due to him bringing the case to Luxembourg. The Ombudsman also intervenes in the rule of law cases before the European Court of Human Rights in Strasbourg. He has already joined 3 such cases and submitted amicus curiae briefs. The Ombudsman has also requested admission to further 5 cases, most recently to the case brought by Judge Tuleya again. The case concerns the interference with his private life and the freedom of expression as consequences of a set of disciplinary proceedings initiated against him. The case may prove important not only for Judge Tuleya himself to obtain individual justice, but may also bring a more general convention guarantee extended to Polish judges who are in a similar situation. If admitted to the case, the Ombudsman will submit written observations to the court within the next 2 or 3 weeks. The case was communicated to the Polish government on 1st September this year, which means that by 24 November, other institutions or organizations may also apply to the court for admission as a third party and provided with the amici curiae opinions. The key concern with the Strasbourg mechanism are, however, the significant delays in communicating cases to government. In this regard, it may be useful to voice the need for the court to handle the rule of law cases in a more efficient manner. During his visit to Strasbourg a month ago, Adam Bodnar met with the court's president, Mr. Roberto Spano, raised the issue of delays and the need to prioritize such cases. And moving to my fourth point, some conclusions. On 12 October this year, the Disciplinary Chamber is to consider a request to waive the immunity of Judge BEATA MORAWIEC. On the same day, a hearing under the urgent procedure will be held before the Grand Chamber of the ECJ in Luxembourg on the execution of the European arrest warrants issued by Polish courts. The measures taken by national authorities against Judges Tuleya, Morawiec, Juszczyszyn, and many others, as well as the Disciplinary Chamber continued activity, may lead to the conclusion that no court and no judge can feel safe in Poland anymore. A pretext can be found for taking measures aimed at disciplining the individual judge and silencing the entire judicial community in Poland. For the time being, the Commission, the Netherlands, and the Polish government have submitted written positions in this case. The question remains open whether other EU member states will attend the hearing to present their assessment of how the dismantling of judicial independence affects confidence in the Polish judiciary and Poland's ability to fully participate in the European judicial cooperation based on mutual recognition of court decisions. In conclusion, I ask myself what Polish judges should do. First, remain judges, the European judges. Polish courts can and should apply the AK ruling of November 2018, as well as may and should resort to the Supreme Court resolution of 23 January this year. In doing so, they have the authority, based on the principle of primacy of EU law, and in the light of the principle of its full effectiveness, to disregard any statutory provisions which stand in the way of the full implementation of EU law and ECJ rulings, I mean especially the Mazel law in this context, as well as disregard the judgments of the Constitutional Tribunal of April this year, declaring the Supreme Court resolution unconstitutional, and likewise disregard any other judgments of national bodies preventing the full implementation of EU law or ECJ rulings, including those of the 2 new chambers of the Supreme Court that either limit the application of the ECJ ruling or even declare it null and void, as did the Disciplinary Chamber a week ago in its decision of 23 September. And I also ask myself what other European actors can do. And this is perhaps the forum that can also provide the answer. For Polish judges, it is not easy today to follow the requirements of independence, knowing that the repressive apparatus of the state can be used against them. It will be easier if they sense the solidarity of other European judges, and if they see that there is no acceptance on the European fora for the oppression of judges, for the adherence to the rules, and the commitment to judicial independence. Thank you very much.
Thank you so much, Dr. Filipek. This may seem a complex subject matter. Those among you who want to dig a bit deeper, I recommend that you have a look at the texts linked in the Facebook advertisement. Read especially the open letter to the President of the EU Commission, Ursula von der Leyen, signed by Professor Pech and 37 other academic experts from 14 countries. Share the letter, and if you like, the YouTube recording of this webinar to friends, and especially friends in high places, if you have some. Now, I say the subject matter may seem technically complex, but at its core, it's simple. It's about the trust we need to maintain and the legal system as a foothold guaranteeing and safeguarding this trust. I'll now play a short summary of the essence articulated by Gerald Knaus, who is director of the European Stability Initiative with its main office in Berlin. This is a think tank which has been working for the protection of human rights in Europe for 20 years. So please listen.
So what is the crisis of the rule of law in Europe right now that should most worry us? If courts can be instructed by ministers of justice, all other rights, the right to free speech, the right to assembly, the right to criticize our government, the right to do things in business which are legal but are not to the liking of some powerful people with connections, all these rights are at risk. And so it is terrifying for the European Union and an existential threat to the idea that all EU laws are applied and defended by independent courts everywhere in the EU. If one government creates a system where the Minister of Justice, a politician, not only directly controls all prosecutors that bring a charge, but also can discipline, threaten, and punish all judges in the country. And this is what has been happening in the last few years in Poland. And this is what the European Court of Justice in Luxembourg has warned about, that it will defend the rule of law, which means fundamentally the independence of courts and judges against pressure from governments. This is existential for the European Union. And how can we do it? Well, the big debate is, how do we strengthen the European Court of Justice when it makes a judgment that we can be sure, a judgment that says that in some country the rule of law and the independence of courts is at risk, will be implemented. And this is what we are proposing.
So with these words, we're drawing to a close. We have done our best to explain the problem and why it should concern everyone. The only thing that remains is the recommendations for doing something about it. So I will leave the last word to Professor Pech to present the actions recommended for European authorities in his open letter. Thank you all for contributing. Thank you all for listening. Professor Pech, the last word is yours.
Thank you very much. So yes, as I said before, we're not talking essentially here about a threat to the rule of law. The rule of law is being destroyed in plain sight. We just cannot accept the resurgence of a Soviet-style justice system in the heart of the EU. We just cannot let this precedent being set. There are many things which can be done. So let me just address some concrete recommendations to a number of actors, beginning with EU institutions. So first of all, it is not true that the EU doesn't have an extensive toolbox. The guardian of the treaty can do better, should do better, must do better, and beginning with more infringement actions. It's just not acceptable that we haven't seen an infringement action targeting the unlawfully composed constitutional tribunal, which is actively undermining the application of EU rule of law standards in Poland. This is an unlawful body, not a court even, so it doesn't even produce rulings anymore. It's just an extension of the ruling party, which is actively undermining the rule of law. It has to be brought to the attention of the EU Court of Justice. Similarly, we need an action against the so-called Extraordinary Chamber, which is essentially suffering from the same flaws as the Disciplinary Chamber. Speaking of the Disciplinary Chamber, where is the application asking the Court of Justice for the imposition of a daily penalty payment? This is the Commission's job. don't want to wait weeks or months for this application to be to be submitted to the Court of Justice. It can be done in 24 hours. So there, the Commission has really no excuse for not doing its job. Also, where is the infringement action regarding the violation of the Court of Justice preliminary ruling of 19 November 2019? I mean, now it has been declared void by a suspended body. I mean, this is just a sick joke at this point. So there are plenty of actions the Commission could undertake, but it needs really to get a sense of urgency. It needs to do its job better, more promptly, and more meaningfully with a sense of purpose. Now, the Council also can do better, can do more. We need to have an Article 7 hearing in respect of Poland now, not in weeks. We need national governments in the Council to ask questions, to ask follow-up questions, and not to accept the lies being fed to them by representatives of the Polish government. I mean, I remember 2 years ago, Polish authorities saying that they're not subjecting their judges for disciplinary investigations for submitting questions to the Court of Justice. This was an obvious lie. We need to make sure that legal and political sanctions follow. If the Commission and the Council don't want to do their job properly, each national government can subject infringement action, can actually initiate infringement action. So it is for each national government at some point to take their responsibilities. And if the guardian of the treaty doesn't want to do his job meaningfully, purposefully, and promptly, then it is for each national government to initiate infringement actions regarding the issues which are not the subject of infringement actions currently. Also, where are the submissions to the Court of Justice in pending cases? So, for instance, Powell was mentioning recent cases, but only very few national governments are actually submitting legal submissions to the Court of Justice. Surely, this doesn't take much resources, and this would show solidarity with the Polish judges and Polish prosecutors who are just punished for actually upholding the rule of law. So this is a very modest step which can be easily taken by national governments. National parliaments can do a lot also. They need to organize hearings about the situation in Poland. Some parliaments have done so in the past. The Dutch parliament, for instance, is one. Other national parliaments should follow suit, and I think the Danish parliament organized a hearing last week. We need to see more of this. So national parliaments can also play a meaningful role in this respect. National courts, not only National Association of Judges, European Association of Judges should obviously raise the alarm as they have. National courts, I would say national judges should now, I'm afraid, consider the suspending by themselves all EU mutual trust-based mechanisms. No, looking beyond the European arrest warrant, essentially now I would say I would encourage every national court in Europe, obviously when in a relevant case, to submit questions to the Court of Justice about whether EU mutual trust-based mechanisms should be suspended in the same way the European arrest warrant must be suspended. As far as the Court of Justice is concerned, the Court of Justice has a very important ruling at the end of October. This is a time to actually review the so-called Selmer precedent, to speak a bit technically. Essentially, it is now the time for the Court of Justice to accept that judicial independence has been structurally disabled. So national courts no longer are independent. Essentially, we are looking at a situation where a country whose authorities have organized the systemic violation of the right to a fair trial by an independent tribunal established by law. We are looking at a systemic violation of this very basic right. It's time for the Court of Justice to let national courts refuse to comply with any European arrest warrants request issued by Polish authorities, simply because judicial independence is gone. This is not a threat. It's actually gone already from my point of view. We cannot expect judges to be brave just to do their job. This is not normal. This is simply a time to raise the alarm in the Court of Justice to essentially quarantine the Polish legal system, I'm afraid. As far as academics, lawyers are concerned, or just more broadly citizens, there are many things you can do. You can write to your national MP, you can write to your member of parliament, you can write to your MEPs to denounce the situation in Poland and ask them what they're doing about it. You can also write directly to Polish authorities, for instance, what the English Bar Council has done recently to denounce the unlawful proceedings against a number of Polish judges. We're talking here about an unlawful body staffed with individuals which have been unlawfully appointed, initiating unlawful proceedings. I mean, this is dictatorship territory. We have reached a dictatorial threshold in Poland, sadly. It pains me to say that. And it pains me to see the inaction from so many actors who should know better. President Marquez did remind us of what happens when we don't take the rule of law seriously and when we don't defend the rule of law seriously. This is a make or break moment. So all national actors, even you behind your computer, can do something by denouncing the situation and showing your support with Polish judges, Polish prosecutors, because you're going to be next. Once Polish judges and Polish prosecutors have been tamed and those actually faithful to their professional obligations have been dismissed or sanctioned, you can be sure that authoritarian authorities are not going to stop there. They're going to go and they're going to move on to their next target. What is the game plan here? We're talking about the rebirth of the one-party state system with Soviet-inspired justice systems. So this is not the time simply to raise the alarm, as many of us have done. This is also a time for European and national institutions to do their jobs. We set up the EU and the Council of Europe post-World War II because I thought we had learned our lessons, but obviously it seems that the supranational systems which we put in place to actually prevent authoritarianism from actually making a comeback in Europe are simply not up to the task anymore. Now, I'm not sure whether this is through denial, through simply a refusal to face up reality, but this is an existential threat to the EU legal order, as was said before. This is a time to act before it's too late. Thank you very much.
Thank you so much, Professor Pech. Stern words, bring them into the remainder of the day and do whatever you can. Thank you to everyone and have a nice Friday.